One. Hi, everyone. I want to welcome you all back. It's been a little while, but I'm here with Frank Ravitch. My name is Larry Backer. We have published the 4th edition of the casebook Law and Religion, Cases and Material with West Academic. And we have, over the course of the last year or so, done a number of conversations about key cases. And we thought, given the tremendous importance of at least two, and Frank and I have been debating whether there's actually three cases that came out of the 2021-2022 term on law and religion, that we should pick this back up and not continue with the older cases, but look at the cases that have just come down. And for today's video, we are going to chat about Carson versus Macon. This is the case involving the Maine's tuition assistance program, but I won't get into it more than that, other than to say we're going to be talking tuition, we're going to be talking Zelman, and we're going to be talking about the transformation of the world as we know it, although we knew it was coming. It's still kind of weird to actually see it happen. And this is no longer your mom, your dad's, or your grandparents' law and religion course anymore. So Frank, why don't you give us a little synopsis and your initial views, and we can go from there.
Yeah, and one quick note also to mention that we're going to be putting up edited versions of Carson v. Macon, the Kennedy coach prayer case, and a note explaining the religious implications of the Dobbs case as well. So everybody keep an eye out for that. It should be up on the website for the casebook by early September at latest. So keep an eye out for those edited versions.
Right. And hold us to it. Hold us to it. We will get it out there for you.
We will. You know, and so that should be available, as well as we will have, as Larry said, we'll have a video on each of these three cases, and so you'll have both the videos and the edited cases. You know, Carson v. Macon is a fascinating case because after Zelman v. Simmons Harris was decided, and the court ignored many years of precedent or misportrayed it, to suggest that that full vouchers or almost full vouchers to religious schools, where 96.4% of the students were using those vouchers at religious schools that could proselytize or whatever, was somehow not a violation of the Establishment Clause. That case was in 2002. We've talked about that in a different video, and it's very clearly discussed in the book as well. But after that case, a question remained open, which is this a may or is this a must? In other words, if a school opens a program to any non-public school, do they have to include religious schools? And over the years, we thought we got answers to that question,
right?
But
the answer was very clear in Locke v. Davey. The answer was that, in fact, we are not dealing just with free exercise. We're dealing with establishment. You have to look at them together, and there is a long historical, despite the fact that these people, the majority of the court ignored this, there's a long historical tradition for treating this as a may and not a must, especially when ultimately what you're doing is funding religious schools. So we thought this.
Well, I would actually disagree.
Yes.
Because as much as I wish that you and also Nelson Tebbe wrote a really great article on this after Locke came out, I wish Locke was that clear. But Locke, Locke in reality, Locke gave a potential provisional answer that there's play in the joints between a state establishment clause and the federal free exercise clause, but it didn't really, it limited it to somebody who's training to be a clergy member. And so it didn't clearly answer the question. I think it certainly hinted at the answer that you're suggesting and that others have suggested, but I don't think the case was actually that.
Well, except to give them credit, and this is a pet peeve I have with the court. Over the past 20 years, this court believes that it and Congress are fungible, and they've been tending to write opinions as if they were statutes, broad-based principles that are meant to apply well beyond the case before them. And you sometimes wonder, and Locke is a reminder, you sometimes wonder whether judges who are exercising their authority under Article 3 and the long common law constitutional traditions of the US and from its predecessors in the UK, that all of a sudden that we criticize Locke because it was quite self-consciously traditionally jurisprudential. It limited itself to the case before it, as opposed to this taste we have, like a taste for fentanyl, with the same deadly results of now recasting these judicial opinions as something like quasi-constitutional legislation, which ought to be quite troubling.
And that's what Zellman was the fentanyl, essentially.
Yes.
But Locke really, I do think was more of a narrow decision. So and of course, starting in 2015, the court started taking the free exercise doctrine in a completely different direction from earlier cases like Lukumi Babalui and cases like that. And so that's really, I think that the heritage of the Carson v. Macon case is the kind of the initial distortion of the Lukumi doctrine in Trinity Lutheran, and then the extreme distortion of it in Espinoza.
Right. Thank you for going there. That's exactly right. And not only that, the complete evisceration of Smith. Which appears nowhere.
What's amazing to me is that in both cases, religious minorities, I think, have been harmed. So Smith, I think, was a very dangerous precedent for religious minorities. That's what RFRAs were originally designed before people were trying to use them to maybe discriminate. RFRAs were originally designed to protect. So Smith didn't help religious minorities. And ironically, the court's new anti-discrimination doctrine in Espinoza and particularly Carson v. Macon is going to be hugely damaging to religious minorities, because as I've written a lot, vouchers in general are hugely damaging to religious minorities. So basically, it's like, it seems that whatever the court does, religious minorities get harmed. And we'll talk more as we go through Carson v. Macon about why voucher programs actually can harm religious minorities.
Right, but and for our listeners, just a background note. The point that Frank is making is a long dispute within the jurisprudence of the religion clauses between a formal test, that is formal compliance, which was Zellman, and an effects test, that is between a formalist analysis and a functionalist analysis. Frank quite rightly criticizes the formalist analysis and embraces the functionalist approach. I tend to be sympathetic, but I'm also extremely sympathetic to a formalist approach as well. But it gets complicated, as Frank suggests, because in effect, formalism can sweep up in ways that you would have thought the Lukumi Babalui case would have made impossible. It does sweep the minority religions basically out of the equation, and effectively creates the possibility that what you're really doing is creating a law of religion for the dominant religions in the country, and that may not be good news.
Which is what Smith, in essence, did, and Scalia actually openly acknowledged it in Smith.
Right, but
the new case is...
Scalia was honest and said this was politics, not jurisprudence. These folks are arguing.
Yeah, that's the
no,
difference. The difference
there's
is
no
these
politics here,
folks
it's under-
are these folks are particularly Espinoza. Trinity you could find some base for, but Espinoza and Carson v. Macon are just unprincipled decisions, both of which actually distort the facts in the case. But there's no acknowledgement of what's going on in Espinoza and Carson v. Macon. You're right. I mean, that's the difference. I mean, Smith, well, we disagree on Smith, but Smith was at least straightforward about what it meant for religious minorities.
Right.
Espinoza and Carson say we're applying an anti-discrimination principle that actually leads to discrimination.
Exactly right. Exactly right. I mean, and that's the thing. We can have a principled disagreement on Smith because we know what we're talking about and no one's hiding anything. Here, there is a little bit of dissimulation in using this hocus pocus of what passes for jurisprudential writing. And I am harshly critical and quite concerned, because if this is the way jurisprudence is now occurring within the American constitutional system in the first third of the 20th century, this, much more than the leak of the abortion case, I think will do long-term substantial harm to the court and its standing than anything else. You can't continue to write this kind of stuff and expect to have any kind of attachment to the people who are expected to kind of embed this in their lives. It's just
exactly. And the sad thing about it is Carson is the least problematic of the three cases, right? I mean, Carson, at least theoretically, we can teach and say, well, this is what the court's doing here, and there's clearly, I mean, it's clearly nonsensical at some level when you consider the history of Maine and the variety of First Circuit decisions that have, explain that the situation in Maine. But when we get to Dobbs and Kennedy, at some point it's hard.
Oh.
The question is, particularly in Kennedy, where it's not only a distortion of the law, but a distortion of the facts at a level well above the normal. Well, we pop the facts a little to go. Majorities have done that for centuries, but although
we've seen, to the court's credit, and this is a backhanded credit, we've seen this kind of distortion before in what was the case, the Good News Club case,
a little bit,
and I mean, Souter was just really good at kind of suggesting that, but.
Priest, but Kennedy, we'll do Kennedy later, takes it to a whole new level. But also, Carson mischaracterizes the Maine program. The Maine program would have allowed religious schools to participate. It's just that they couldn't. It didn't matter whether you were a religious school or not a religious school. It wasn't based on status, which is what the court had talked about in Espinoza and Trinity Lutheran.
Which is now gone.
It was based on whether you're proselytizing, on whether you're enforcing or requiring religion to be taught. So suddenly, boom, status, which was the core of Trinity Lutheran and Espinoza, is out the window. And now we have this decision that ignores what the Maine program actually did, which is it didn't distinguish between religious schools and non-religious schools. It distinguished between schools that proselytize, or schools that were engaged in religious teaching or activities. Now, look, I understand why people would say, well, that's a distinction without a difference. That's Justice Gorsuch's position in Espinoza and in Trinity Lutheran. But it is actually a distinction with a difference. And we'll talk about that as we go through this case.
Right. So here's my take. And why I find the Carson case distasteful.
You're so kind. I'm going to borrow that. I'm going to use the term distasteful instead of unprincipled.
And I find it distasteful because I think that they were not honest. It's a dishonest opinion. If I were to write, and I am sympathetic to some large extent to the result, and I know you and I are going to disagree on that, but here's the way. If you are going to write an opinion like this and you have the courage of your convictions, and I'm not sure they do, you would have written the opinion. I would have written the opinion a little differently. I would have said, look, we do not believe, we have never believed in the wall of separation We believe that since 1947, the wall of separation has gotten in the way of the proper development of both the establishment clause limitations, and the application and the flowering of free exercise. We tend to believe that religion ought to be deeply embedded in our life, including our public life. We don't fear it, but we tend to privilege over the establishment clause. We tend to privilege the religious freedoms of individuals and their free exercise in the context of governmental programs. Therefore, we believe that even though, and we also believe in a formalist analysis, that in fact, if it's formally okay, as long as everyone has the space to in the marketplace of religious schools, then it's all good. And if we put all of this together, it would have been a 3-page opinion. If you put all of this together, we would have overturned and completely rejected the wall of separation doctrine. We would have taken as our standard position that in fact, it's the free exercise clause that drives the religion clauses, and that on that, and we do not fear, as long as the state is not embracing a religion in toto and enforcing it on someone, that we believe that free exercise ought to drive it, that we can directly fund a private education as long as it's being driven by parents, and therefore the main statute provisions are invalid. Done. That would have been the opinion. We would have had lots to argue about, but we would have been arguing honestly.
Yeah, I think, if I were to find a way to come to the same conclusion as this court did, my opinion would be somewhat similar to yours, but probably, would have explained that maybe kind of what Scalia did in Smith, that vouchers have a very negative impact on religions that don't have enough people to create a school for their religion, and that while this program is, the situation in Maine is unique, in many jurisdictions, that religious minorities are going to be harmed by this, because they're going to have a choice to send their children to schools of religions that are big enough to have religious private schools. And those schools either proselytize directly or by example. And the other choice would be to stay in public schools that now may be underfunded because of voucher programs.
Right.
So for religious minority, I think I would be honest about that. And then I would say, I can't really imagine myself coming, I would probably say, but Maine's different. And so in the case of Maine, where there's no status-based distinction, and there's not even public schools in some areas, the Maine law, the Maine rule can stay in place, but as a general matter, this would be discriminatory. But we have to acknowledge that by finding this discriminatory and therefore allowing vouchers, we're going to be privileging religions. Privileging isn't the right term. We're going to be favoring religions, right, that have large enough populations to have their own schools, and that this will likely harm and has historically harmed religious minorities. And then you can honestly say that the rest of it would be similar to yours, which is you'd have to acknowledge what you're doing to the establishment.
Exactly. And then you can duke it out. Yeah, so then you can duke it out. That's a brilliant analysis, and it leads me to the following. If in fact what you say is right, and I'm sympathetic, doesn't it also necessarily follow that if you mean what you say about neutrality in the context and that we're dealing with, and with respect to the principle that you have stated, of protection of minority religions, which this court has embraced and has embraced since the REFRA cases, right? There's very little argument about that, that in fact, the case after Carson has to be that if in fact Carson is valid, then states that do a Carson-like program also have a mandatory obligation to subsidize minority religions that don't have enough people to financially support it, to subsidize them so that they can develop equally available schools. so that
So
we're
I
not.
think the current court would suddenly find the Establishment Clause again in that context. And you know, and I don't think they would expand free exercise to the point of requiring subsidies.
But that's where the case is going.
I mean, they are requiring
If they buy
subsidies in Carson.
Right. If you buy what they say, it is inevitably true that neutrality is neutrality, and you cannot do an invisible subsidy in one case and then say, oh, well, no, we're only dealing with these people. Neutrality is neutrality. And
You hit it. By the way, I love the way you put that, because what Carson and Espinoza are, they are invisible. So that was perfect. Those are invisible subsidies for larger religions.
Larger religions with long traditions of independent school systems,
yeah,
right? That, like large brands, I mean, this is the economic model, like large cereal brands can then choke out the ability of others to put their product on the market.
And then the irony is, if we go the route that you're talking about, where because of Carson v. Macon, we go to this, well, now we need to subsidize the religious, schools for religious minorities, which if Carson leads to what it's likely to lead to, because Zellman sure as heck led to that. Right. In school districts that had, I'm reminded of the Jehovah's Witness mother who spoke after the Zellman decision. It's like, what do I do now? I can send my children to a religious private school and sacrifice their eternal soul because they might change, they might be proselytized, or I can keep them in the Cleveland public schools, which are already problematic and now have lost a lot of the best students and a lot of funding. So do I give up their eternal future or their earthly future? And I think she didn't realize how directly relevant I think that analysis is to, I mean, there's no way she could have realized 20 years later,
right
after Carson v. Macon, she was right on then. She was exactly right then.
The court has crossed that river.
Yeah,
and now, what is it that someone once said, you broke it, you buy it. They have broken the old consensus, 1947 to 2000. Well, okay, perfectly plausible, even if we would disagree.
Yeah.
Now that you've done it, you got to own it.
Yeah, and the thing is, they don't own it. Going to the details of Carson, right? So you've got the main program, which has, essentially it's vouchers, but it's because Maine has so many areas with low populations. There's no public schools in some of those areas. And so Maine has always supported secular private schools or religious private schools that don't have a religious curriculum. And there are a lot of those in New England. And so, the reality is that, under the Maine Constitution, and it was not a baby Blaine, it was not a Blaine amendment under the Maine Constitution. Which is ironic because James Blaine was from Maine, but the provision at issue here wasn't that one. There was a baby Blaine there, but that wasn't the issue here. And so, the reality is that, Maine situation is somewhat unique. So these private schools are essentially stand-in public schools.
Right.
Now the court was right. They didn't have the requirement community schools might have, to follow the constitutional law, but they were essentially stand-in public schools. And now the court's saying you have to include these religious schools. But going exactly to what you were talking about is the sort of, I don't know if I'd go so far as to say intellectual dishonesty. I would go that far in Kennedy. I wouldn't go as, and I think you were right. You kept short of that. I think you were kind of saying disingenuous or maybe unprincipled in a way. I mean, I think in Dobbs and Kennedy, I've seen a number of people use the term intellectually dishonest, and that's certainly, I think the term may fit there. Here, I think, like you said, disingenuous, and where they're really disingenuous is the way Trinity Lutheran was a fundamental change in the law, because
Right.
before that, we thought that in order to have discrimination that violates the free exercise clause, you need to have some kind of animus, like happened in Lukumi Babalui. That was kind of the understanding to Trinity Lutheran. And then in Trinity Lutheran, it was a 7-2, and why? Because the court said, look, this is a status-based distinction, and that's why. If you're religious, you can't have it. If you're not religious, you can have it. And that status-based distinction was really important. And then there was that footnote 4, which said, or footnote 3, which said, and playground chips have no religious content, because playground chips were the issues in Trinity Lutheran. Then we get to Espinoza, which is a 5-4. And in Espinoza, suddenly we're still talking about status, but suddenly that footnote 3 has disappeared.
Right.
Suddenly nobody's talking about, it doesn't matter what the substance of it is, but it's still status versus use still matters. And then we get to, Carson v. Macon, and all of this is within like 5 years,
Right.
Then we get to Carson v. Macon, and suddenly status is gone. Suddenly, and the line is itself very disingenuous. It doesn't really matter whether it's status or use. Well, that was Justice Gorsuch's concurring opinion in Trinity Lutheran and Espinoza. If you're thinking that now, why weren't you thinking that then? And certainly you would not have had a 7-2 in Trinity Lutheran if you said that. Right. Because it would have not had footnote 3, and there's no way that Breyer and Kagan come over on that one.
Right.
So, if you look at it, it's like telegraph dishonesty, because now we get Carson v. Macon, and suddenly this status use distinction is gone less than 5 years, when it became the major, in Trinity Lutheran, that was the major thrust of the majority opinion. And in fact, the concurrence, Gorsuch's concurrence, points that out in Trinity. We don't need the status use distinction. And the majority pushes back on that. And suddenly, here we are 5 years later in Carson v. Macon, and boom, it's gone.
And it's gone. And it was clear that it was going to have to be gone, because we went through this with the Lemon test. Every time you have these kind of highly technical jurisprudential distinctions, they have a half-life of a mayfly. The judges just can't, jurisprudential, it sounds really nice. And it's very useful when you are engaging in a revolutionary act of shifting from one jurisprudential lens to another. But once you're done, it's not useful anymore.
Once it becomes really inconvenient, like here,
exactly
where
right.
Maine did not discriminate based on status at all. Religious schools were eligible, and some of them even received, but they were not, they were religious schools like Harvard is a religious school, right? They were religious schools, but that had a religious history, but were not really not a religious curriculum. I mean, there may have been prayer opportunities if people wanted them, but that make the status use distinction unhelpful to what the majority wanted to do. Right.
And I mean, for me, Trinity Lutheran was kind of like the traditionalist version of the Lemon test, because you wound up in exactly the same place, but now in bizarro land, the mirror has been inverted, and you had the same problem. So now we're going to have to deal with this the way, well, can we give them a textbook? What if we send them off to a religious school? What if we put a little a portable classroom next to them? You remember all of those cases?
Oh, the craziness, yeah.
Crazy.
I mean, Lemon was taken way too far in those cases.
Right. Yeah. And so from my perspective, at least Carson has the benefit of finally saying, look, we no longer have to engage in that. We don't have to walk down the road, the subterfuge road of Trinity and of Espinoza. It's now clear, but my problem is it's still not clear, because in all three cases they're avoiding the real issue, which is we are going to revolutionize and reframe the relationship between establishment and free exercise.
Yeah, and I think you're absolutely right there. On both counts. I mean, one thing is taking Carson v. Macon at face value. at least the answer is now clear, right? So we now know there's the battles over status use, the battles over whether this requires any sort of intentional discrimination. That's pretty much over, right? So that in that sense,
For the
it's really
moment, because we know after Dobbs that a precedent doesn't have very much value if it's inconvenient. But
well,
okay.
that's the there's that whole. And in Dobbs and Kennedy, that can of worms will definitely get open.
We'll get there. We'll get there.
But there's. I know we disagree. I tend to have a certain fealty to precedent, unless it's like Ackerman suggests a constitutional moment, and is more and how he described in some of his later work and on that issue. And this was certainly not a constitutional moment in that sense. But it does make it clear, and the problem is that it overlooks real religious minorities who are going to be hurt by this, just like they were hurt by Zellman. This is about freedom of, and I'm a strong, I would overturn Smith. If it was,
no,
so
no.
yeah, I mean,
we're gonna have to have a debate about that.
But bear in mind, I would overturn Smith pre-Hobby Lobby, so that Reynolds v. United States, not Reynolds, United States v. Lee was clear, in my view, it was clear that for-profit entities are not protected by the free exercise clause, unless maybe they're sole proprietorships or something, right? But I would overturn Smith.
Yeah.
So
the court has twisted itself there into
when it comes to religious freedom, like we have some different views on that, but in the end, as you suggest, this is not the way to really get there, because we can't. It does make it clear, but you're still boxing with shadows and trying to figure out why it's clear.
That's exactly right. And for our listeners, I promise you at some point, we're going to have the great Frank versus Larry debate on Smith. And I must be the only person left in America who still thinks of Smith with any kind of positive inclination. But
no, you're not. I think there's a lot of people that agree with you on that. And if you look at people like me and maybe Step Feldman and some other folks, our perspective on Smith is that free exercise in the lower courts, exemptions generally help religious minorities who are frequently overlooked in the legislative process. There's no reason legislatures should think of 1,000 different religions that they don't know about. And so that Smith and ultimately RFRA, there have been articles that have pointed this out, primarily benefit religious minorities, but now they're maybe being misused for other purposes.
Exactly.
And so
right. And this is the problem with a hammer. Right, the hammer knows a nail, and in this case, this hammer is now working on majority religions rather than. But we're going to.
And the response to Dobbs under RFRAs will actually be, and under free exercise will actually be a big test of whether minority religions count, because there are RFRA claims after Dobbs under state RFRAs, and there will be free exercise claims probably under Carson.
And foreshadowing. This is foreshadowing. So stay tuned.
So we'll talk about that in the Dobbs. Yeah. And so, do they really? Does this doctrine really hold? Does Carson really hold?
Oh my God. All right. So I want to turn our attention to two other things, because I know our time is kind of running short.
Yeah. Sorry if we seem animated, but this is the first time we're getting to talk. I'm talking to the audience. We're very excited, but not happy excited. To be discussing. We're happy and excited to be discussing it with each other, because that's always fun, and to be discussing it with you, because that's always fun. But these decisions are problematic. So it's
right. And there'll be a lot of debate, and you all are welcome to take whatever position you ultimately want to take.
Exactly.
But let's enjoy the debate. All right. So here's the two things that we cannot overlook in any discussion of Carson. One is Breyer, the last big hurrah, and two is Sotomayor.
Yeah.
Right. And so I'm really curious about your take on both.
Well, I think, obviously Sotomayor's dissent was scathing, to say the least. And I think she hit the nail right on the head, because she kind of said what you said. Look, if you're going to be honest about this, then don't distort free exercise jurisprudence and don't distort Establishment Clause jurisprudence.
Right.
You know,
Or embrace your distortion as law. I mean, that would be cool too. Hey, folks, we're transforming things. We can because we think everything has been misread, and here it is. That would have been okay. You could have argued with it, but it would have been at least honest. But anyway,
it would have been at least honest. And she calls it out. She says, look, you know, first of all, Zellman was a distortion, but even if Zellman wasn't a distortion, then she points Locke v. Davy, right? So, you know, this is not necessary after Zellman, and raises both establishment and free exercise issues. And she calls the court out. Yep. What about the status use? She talks about what they said in Trinity and Espinoza and points out Espinoza was just like a year ago. What the hell's going on here? And I love the way she, I mean, it's in your face.
She knows what's going on. She knows what's going on. But she's got to do it rhetorically.
Yeah. And I think Justice Breyer, you know, I think as a last hurrah, it was really Breyer-esque. Breyer has always had a way with navigating very tough issues, and calling things out for what they are, but he's you know, it's more of a like kind of a soft punch.
You thought it was soft. I thought it was really hard and absolutely correct, even though he's been ignored for 20 years.
Oh, no, I think he's absolutely right. But I think he said it because Sotomayor's dissent was kind of, you know, I think his might be perceived as soft, or maybe like his concurrence in Van Orden.
Right, the language was less passionate, but I think it was equally deeply felt.
Yeah, the point was, Breyer's point, it reminded me of Souter dissents.
Yes.
Which is a huge compliment, right?
Yes.
You think back to Souter's dissent in Zellman, you think back to Souter's dissent in a case, 11th Amendment case called Alden v. Maine, and like he just takes a scalpel to it.
Right. And I really do miss that. I really do miss that person on the court.
I do too. It's just
even when I disagreed with him, you know, it was a pleasure to read, and he made you think.
He made you think, and it was like watching a brain surgeon at work. Yeah. I mean, he just found every little detail. And I think that's kind of really Breyer here. But as you said, it's a conclusion to 20 years of very thoughtful writing on his part in religion clause cases. People can agree or disagree with him. Yeah. But he has had some very, very thoughtful analysis under both the free exercise clause, under the establishment clause, under obviously a number of other non-religion related constitutional questions, and this really does reflect that. I mean, it's very thoughtful, and I felt it was like a lighter touch because I think he had to be seething. I think he had to be seething because he and Kagan, I think, both had to be seething because of joining in Trinity Lutheran with the understanding that there's the status use distinction, and at least a majority of the court, including the dissenters, supporting footnote 3.
Yeah, no, they were used. It's a nicer way of putting they were betrayed, but they were used. But I mean, I really embraced, and it's taken me a while to come around to it. But the fundamental notion within the religion clause jurisprudence of looking at a religious, advancing or avoiding religious strife standard, I think is something that ought to have been, and it aligns nicely with protecting the rights of minority religions as well. But that is a standard that ought to have been given far more attention than I think anyone on the court has bothered with over the last 20 years or so.
Yeah, and he's exactly right. I mean, if you, the irony to getting rid of that, getting rid of divisiveness analysis in Agostini v. Felton, at least in the aid context, is if you are an originalist or you support originalism, the one thing we do know, I mean, even in things like the Federalist number 10, the divisiveness that religious disagreement or religious factions can cause is mentioned. And we do know that's something the framers were concerned about. So, I mean, it's odd that it's gone. And Breyer, Breyer's been right all along. He and Souter and Stevens too.
I mean, they're the only original, and oddly enough, Breyer is the only originalist on this opinion. And you're sitting here and going, oh my Lord, you'd expect this somewhere else. But no, it's Breyer who's actually bringing out the foundation that we haven't seen really since 1947. And of course, the Agostini case, but since 1947, people, and part of that is because, in a sense, my guess is, until very recently, we had come such a long way from the immediacy of this kind of strife, the riots, the deaths, and all of this. We've come such a long way that these folks just don't understand the potency, the violent potency of fanning religious strife, and of the importance for the solidarity of the Republic in creating a jurisprudence that in fact is geared towards minimizing that possibility.
Yeah, and it's amazing because Carson and Zellman, to me, in both cases in which the dissents point out this divisiveness over funding and things like that, it's a slap in the face to all. I mean, if you look at the 19th century, all the, think about all the situations in which there were riots against Catholics and Catholics were murdered. Why? Because of this factionalism, this religious factionalism, and a concern over, in that case, the economic pie of jobs, but then religion was used as a proxy for that, in the Bible riots and things like that, and in the 1840s. And now the court's welcoming that again, because now that vouchers are going to be funded, there's a limited pie, right? I mean, the court opened it in Zellman, but in Carson, at least until Carson, at least states might be able to avoid that by saying, well, yeah, we're not going to include religious schools, or maybe at least until Espinoza. But now after Carson, states have to do that. So maybe they drop the programs, but now it becomes a political battle over the financial pie. And what about when a small religious group then says, I want a subsidy,
Right. Yes.
What's going to happen to them?
Yes, there you go.
And then the big religious groups will start fighting with each other over,
But religious strife, I mean, given Carson, the religious strife argument is really the basis for saying, hey, you have to be able to fund these other religions in their ability to reach these students, or you will, in fact, what you've done is now created the perfect storm for reenacting this kind of religious strife, a domination by the big religious groups that increasingly begin to think that they have an in or an entree or a more intimate connection with the mechanics of state, and everyone else being marginalized. That is the recipe.
And you can see
religious strife.
You can see it coming, because even then, non-religious or people, there are going to be people who don't want to fund Catholic schools. There are going to be people who don't want to fund evangelical schools. Those are the two largest.
And no one is going to want to fund Satanist schools, or but
there's going to be a lot of places where no one wants to fund Jewish schools or Muslim schools or
that's the test. That's the test. I mean,
what about non-religious schools now competing with people, atheists and agnostics, I mean, and a lot of religious people don't want their money going to fund religious schools. So this is going to now be open war. It'll take a few years for it to happen, but that's what it's going to be.
It's coming. All right, we have really tried our listeners' patience a great deal.
So. We're both so animated about this for.
Right. Wait until the other two cases, which.
Oh my God! I think I'm gonna have to not drink coffee for 3 days before talking about Dobbs or Kennedy, because otherwise, I literally, my head might explode. At least there won't be any hair to lose.
Oh, but it'll be fun. It'll be fun.
Yeah.
So, any last words on this case?
What I think is, look, I agree with what you said. Whatever you think about this case, And I think both Larry and I are somewhat sympathetic to the result, although I have my clear worries about the impact on religious minorities. But whatever you think about this case, when you look at it, I think you want to ask yourself, what is the line from Lukumi Babaluai to Trinity Lutheran to Espinoza to Carson v. Macon? Because the line, it's going to confuse students. I think it confuses scholars, right? I mean, it confuses me. Like, why, how did we get here in the way that we got here? And then the same thing with the Establishment Clause. You know, Zellman Locke, and now we're here. So, think about those things, I think, when you do the cases, and let us know if you have things, if there are things we didn't think of that you would like to criticize, or if you want to defend. You know, we're more attacking the disingenuousness. People can disagree about results.
Right. And my last word is a simple one. It's two words: Everson and Smith. And I think that one cannot really appreciate the extraordinary transformation of this case, whether one agrees with it or not, without having both Everson and Smith very firmly in mind. And that really is the beginning rather than the end of the conversation that Carson has now invited us to partake, whether we want to or not. Please forgive me, but I'm going to say it. God help us.
I'm you know, as a religious person myself, I'm with you on that. We, you know, certainly the court's not going to help us. So, you know,
so we'll see. Anyway, folks, thank you very much. And we hope you enjoyed it. Stay tuned for the next ones. And absolutely agree with Frank. We love the engagement. Reach out, and this is an ongoing conversation, and probably will, when we do this again at the end of the next term in 2023, it'll be even more interesting, and we'll look back on this and go, oh my God, if we only knew what was coming. So
I was so concerned after Espinoza, and now I'm like, why was I worried after Espinoza?
The good old days, the good old days. All right.
Bye-bye.